Mr. Speaker.
Jacinda Ardern.
Thank you, Mr. Speaker. It's my pleasure to contribute to the second reading debate on the Social Security Clothing Allowances for Orphans and Unsupported Children Amendment Bill. And I'll begin as other members in this House have done as well, and thank and commend Tracy Martin for bringing this bill to the House. It is absolutely the right thing to do, and I'm pleased to see that it has been supported by the government. I wonder whether or not greater immediacy to the implementation of the bill would equally still be supported by the government, because we would certainly like to have seen, if they agree, that if indeed the government agrees that this is a beneficial amendment, then it's beneficial tomorrow. Rather than in some time in the future, so that we would continue to encourage government members to just take that extra step. I think the member Tracy Martin has done well to bring the stories to the House of the origins of this bill. Just to extend though a little bit of the comparison between the two types of distinctions that we have in our legislation currently around a foster child and the difference in treatment that they will receive or that their carers will receive than if they are on an unsupported child benefit, because there isn't parity between the two in terms of those additional allowances. Now, yes, extending the clothing allowance is a significant contribution, but our concern is that we would like to see parity in all allowances. Because what, Mr. Speaker, is the difference between a child who has been cared for by someone who is not their biological parent, but through reasons that are not of their own choosing, having to be supported by someone else. And that is through the goodwill of that someone else that they are being raised in a loving and caring home, but often without the financial resources to necessarily deal with that new member of their home. In fact, if anything, it's often a foster carer who may be able to do more pre-planning around these circumstances to deal with the change in income that they may experience as a result of taking on a child into their home, whereas those often who are on an unsupported child benefit are often family members who are taking in a child because they feel compelled to ensure that child is still cared for within their family, and so are less likely necessarily to be able to manage their financial circumstance or to plan their financial circumstance to accommodate that extra cost. So it's Labor policy that we would like to see, for instance, grandparents raising grandchildren who represent a significant number of people who are in receipt of the unsupported child benefit, to receive the same access to allowances as a foster care family would. We think that makes absolute sense. One of our other concerns with the unsupported child benefit, and it seems wise to raise it at this juncture, is that a number of families struggle to access the unsupported child benefit. I've had a number of grandparents who have contacted my office seeking assistance just to get that basic allowance, let alone access to the other allowances which the member is trying to extend to them. The threshold for an unsupported child benefit is very high. The family member has to demonstrate that there's been a breakdown in the family, in the relationship, which means it is that child is no longer able to be cared for by their biological parent or their long-term guardian and caregiver. That often places a grandparent in a very difficult situation where they're forced to demonstrate the dysfunction in their own family, even though they may have been caring for that child for a number of months, thus demonstrating that they are the ones that have been compelled to take up the care of that child. And the other issue that it causes is that if a grandparent seeks the unsupported child benefit, there have been situations where the parent who may be in receipt of a benefit, which as a result of caring for a child, and then therefore the grandparent seeking that benefit and support triggers working income, seeing that the parent is no longer caring for the child and is no longer eligible for instance, sole parent support. causing that parent to then go and try and take back a child from a grandparent who they've been cared for because that is the best place for them to be cared for. Now, I'm not arguing that it's right that someone be able to access an unsupported child benefit when they're not supporting a child, but you can see the complexity of the family situations that often these grandparents are having to deal with. They're difficult, and we should ease the path as much as possible. And at the moment, having to care for a child up to a year to demonstrate that they're the long-term caregiver is a significant barrier for those grandparents. Two other issues that I would like to raise that is relevant to this debate is that a lot of our foster carers who are currently in receipt of these allowances, and they might include allowances for Christmas and birthday presents, health and education costs, and other financial assistance for recreational items that just come with caring for a child. A foster carer who may be in receipt of those allowances often are now being encouraged by MSD to take bulk one-off payments in exchange for becoming Home for Life parents. Now, there's two issues with this. Home for Life seems to have been used as an intermediary for adoption, rather than actually reforming our troubled and antiquated adoption laws. Secondly, Home for Life in and of itself has meant that some families have thought that they will get greater legal certainty by moving to this different classification, when actually, to date, they still deal with the same issues that they might have dealt with as a foster carer. For instance, a litigious biological parent who constantly challenges any decisions, battles for access rights when that's clearly not appropriate. And none of that is necessarily resolved with Home for Life. In fact, all it does is leave what was previously a foster carer without the allowances and access for support that they may have otherwise had. Now, a lot of families who move to Home for Life do so because they want to indicate to the child they care for that it's not about that financial support, that they want that legal recognition. But when they do so, they're also finding they're abandoned by SIFs in terms of long-term support with the legal challenges they face with biological parents and with other issues like conduct disorder. So if we want to make sure that we are giving a secure family home for a child who's either being supported in an unsupported child benefit, a foster care family, or a Home for Life, we need to make sure that the support is appropriately tailored for each of those different circumstances, and currently they're not. The second point that I wanted to raise relates to the age at which a child is covered for these different categories. The Child, Youth and Family Act currently classifies a child as being a child until their 17th birthday. Now, if I asked any parent in this house whether they, at the time that their child turns 17, would pack their bags, send them out the door, and tell them to never return, ask for money, help, support, housing, food, clothing, or even emotional help, because it's game up. You're 17 and you're on your way. I know plenty of parents who would like to have at times done that, but reasonably never would have. And yet the state, the parent of last resort, does exactly that. They functionally switch all support off legally at the age of 17. Now, I think it would be hard for many of us in this house to fathom that, which is why those who work in the care and protection space, the Dingwell Trust, LifeWise, many other agencies, are calling upon us as parliamentarians to lift the age from 17 to at least 18. Let's at least bridge the gap so a young person's eligible to sign a tenancy agreement or get a Housing New Zealand house or access some unemployment benefit if they need to. But at the moment, we have a gap in our law. Now, I would plead with members of this House to take up the opportunity to bridge that gap. We've asked ministers before, but it seems pertinent here because that would, of course, as far as I understand it, would extend the support that this bill would give to what I think is a reasonable age, and that is just the age of 18. So these, Mr. Speaker, are extra issues that I would ask this House to consider But otherwise, I commend Tracy Martin for the work she's done in bringing this bill to the House.